Hello, everyone. Welcome to our weekly Sunday meeting. So this is a meeting where we usually are talking about medical topics, and this is a closed forum of all the doctors who've been associated with Dr. K. Agarwal in the past. But today we are going to be talking about a very pertinent topic, and that is about the rights of doctors. With everything that is going on in the country, and especially in Rajasthan, we thought it would be pertinent to call upon Anupam Sanghi. She is she's a senior commercial mediator and litigator, and usually her expertise lies in telecom, media, and technology. But she does offer a holistic approach to simplify the complex and legal regulatory framework for clients, and helps them in helps to counsel them with all their problems. Today, she's going to be discussing the medical issues, the medical legal issues that we as doctors might be facing. She has interacted with Dr. KK in the past, and we are very fortunate for her to be here and share all the anecdotal experiences that even sir might have shared with us. So without much ado, I would hand it over to Miss Sanghi and request that we talk about what is happening in the country at the moment, the recent events, and then we can move on to the other rights of the doctor. So I present to you Miss Anupam Sanghi. Over to you, Mrs. Sanghi.
Thank you, Dr. Meenakshi, and all the doctors on this forum. It's a real pleasure to be on Dr. KK's forum and to be amongst his colleagues and equally compassionate doctors. I would have always loved to carry on the work which Dr. KK wanted to do, and this is a great opportunity, I think, for all of us. And we must take it up as seriously as he would. So I think he would have talked a lot about this going on, and he would have really gone to the rescue of doctors, So, well, this is not something very unusual, especially in the time of patient's death. Such a thing happens that, the doctors are blamed, and there's a whole, uproar against them. Now with social media, it's really heightened. So this particular story seems to be a very sad story where two women had to give their lives to, one doctor, one patient. It seems like a case where in her dying declaration, the doctor has said it was postpartum hemorrhage or a lot of bleeding by the patient. She couldn't have stopped it, and maybe it was really unfortunate that such a thing happened for the patient, and for the doctor, it's really unfortunate that she just couldn't take the blame and she committed suicide. Although suicide is not something that needs to be really sympathized in some sense, because we should not encourage cowardice. I wish this doctor had taken it up as a challenge, and like some other doctors who have taken it up right up to the Supreme Court and fought it and created a precedence, and she would have helped the other doctors. So she should have shown a little more courage. But it happens that, many times the weaker side takes over us. So essentially, the term medical negligence is something that has come to be understood as a wrongful act, or some act that has not been committed at the time of giving the treatment, or it has been omitted, or it has been committed in such a wrong way. So any kind of wrongful action is known to be medical negligence, although there's no strict definition in any law till date. So what happens is that it's a sort of gray area which became more and more clear because of courts' decisions. So courts have been very clear about this, standard of care and how to assess it. But doctors are not so aware. So because it's become like a legal interpretation, and I guess what Dr. KQ would also say, there's lack of awareness. He was better than the lawyers in understanding this term and in explaining it even to us. I had gone to him for a couple of my cases which I was handling for the doctor, against the doctor. So this requires some understanding, because ultimately it goes to your technical understanding, of what would have caused negligence. That's a technical matter, what every doctor would do. So first, when a doctor is pursuing professional duty, what is the duty of care, what is the standard of care, is the first question that arises. So first of all, whether he has how he gets how there is a legal duty, because of the oath that you have taken, and because of the professional ethics as prescribed in your by the professional bodies, medical council, and the oath declaration, etc. So there's a legal duty. Now, while performing that legal duty, whether you have performed it with due care, whether you have performed it with the standard that is expected of an ordinary competent doctor, not of an extraordinary doctor, creating miracles. So that is really assessed, whether your competence was there, whether you accepted the patient because of the competence, not because you thought that you're an MBBS and you can just take up any case which you don't understand. Or of course, MBBS is very general and generalistic, and if it allows you to take up any case, that's fine. But if it's a special case, whether you should have taken it up or you should have referred it to a specialist, firstly. So whether you were competent to take up, the patient under your care. Then what is the treatment that you would have given? What would the other doctors do? There has to be some sort of a norm or a standard, or approach that doctors follow. It cannot be so out of the way that other doctors cannot understand that how come this doctor took this treatment. So it has to fall within certain standards. It has to fall within the commentaries of medical commentaries written by with a lot of research, that okay, you can support it with this research, that you have read it, and whatever treatment you are giving is supported with research, because ultimately it's all about going with empirical evidence, going with what has worked, what kind of medicines have worked, what kind of treatments have worked. That's how medical practice is. So whether you administered the treatment correctly. Now the other aspect of it is that how properly did you execute the treatment, how diligently did you give that treatment to the patient, whether you left something in the operation in the body, whether whether you did the correct diagnosis or not, then whether you got the right reports that were required before operating, or whether you deferred certain things, whether you delayed on certain aspects that you shouldn't have. So many such accuracies and inaccuracies can be pointed out by other doctors when it comes to how well did you administer that treatment. So even in this particular case, I think it would have been very easy to check whether this was whether it was a simple case of ultimately so many deliveries take place. So whether she was following the correct treatment, whether the doctor was administering it properly. Now, whenever there's a harm, then how it has been caused. So any other doctor would be able to judge that, oh, if she would have done this, then there wouldn't have been any harm. And any ordinary doctor would follow this kind of thing. Or when there was in case of emergency, this is what the doctor would do, or whether anesthesia was administered properly or not. So many aspects that a doctor can only talk of from the technical aspect will depend on whether the harm or the damage caused to the patient was directly related to the negligence, or directly related to the actions taken by the doctor or not taken by the doctor. So you have to check the counterfactual, that what if she would have done this. But you cannot go against her error of judgment. Like, it's a professional, every professional has that discretion of following a certain treatment, of following a certain judgment. Even we lawyers do. We don't guarantee winning every case. And so certainly the doctors cannot guarantee. That's why you have get consent forms signed. I'll talk a little more about the consent, which even Dr. KK used to feel very strongly about. Now, when you are, when you are blaming any doctor that, this was the harm caused, or when you are supporting any doctor that, she did everything under her duty, under her standard of care, and, it was just unfortunate that the body of the patient could not take it. There's so many times that happens. And Ayurveda only goes by, how your body can react, or how your body will has certain balances or imbalances on a daily basis. So, we have an age-old science which talks about it. So certainly, everybody is not same. Now, point is that so the processes and the competence that a doctor must have is clearly known by certain standards that you people follow. Now, if it has not been followed, then there's a principle called res ipsa loquitur, or the thing that speaks for itself. If this would have been done, if crocin would have been given, these are the aspects, that this is how the patient would react. If brufen would be given, this is how the patient would, maximum, what is the worst case scenario that can happen. If a drug is reacting to a patient, then, why is it reacting? So it's all known, okay? And especially under, regular treatments, like in this doctor's case, it's not something that out of the ordinary that was happening. So now, once you can show that, this is the thing speaks for itself, this is what would have happened, and this is the worst case scenario, then the burden shifts. This is the burden of showing negligence is on the person who's alleging it, which is the patient's family in case of death. And in case of the patient doesn't die, then the patient many a times files cases against the doctors. So point is that whether the patient has been able to show it with enough burden of proof that there's a high suspicion or a high degree of evidence available to show that the doctor did not perform the duty well. I was dealing with a doctor's case who's treating for cataract. This patient for cataract, he had done a cataract operation. Now this patient was from the village. Clearly, the prescription said that there is an infection which has happened, and so you need to take one injection. Now he was scared. He refused to take the injection. So the doctor prescribed him medicine, to get rid of the infection. And then after a few days, when the infection did not go, again the doctor said, we must give this injection. Again he ran away, and he went away to some other hospital for treatment. Now this patient runs away. He doesn't take the treatment given by the doctor, and then he loses the eye. So he files a case against the doctor. This case, when it goes against the doctor because the patient has lost the eye, that sympathy factor is there. And as I said, medical negligence is very broad term. So, there's a lot of leeway on both sides to show. Now, according to me, the lawyer or the doctor had not made out a very good case by the time it reached the National Commission in Delhi. So we filed an appeal in Delhi before the National Forum. Now, in that, we had to show from medical literature and from experts' opinions that how he had followed his standard of care. But can you imagine that even in the National Commission, the sympathy for losing the eye of a poor man was so much that a good, reasonable judge, because he's also a human being, he says that no, this doctor has not given enough awareness to the patient. the consent is not properly given. Show me how the consent was given. So consent becomes very important to save yourself. This is the only way the doctors can save themselves, by saying that we explained this to the doctor, we explained this to the patient. So generally there are standard form of consent and you make them sign this. But when you're giving some drug in which, relating to infection or whatever, you can explain it to them. Now, how do you record it that, it was explained? There's no record because you're verbally explained. So Dr. KK was very keen that there should be a video consent in case of every, treatment. So when the doctors explain what is the reaction of drugs or what the treatment they are following because of certain reasons, then it's a clear evidence of how the doctor has applied his mind. And there's no intention of, harming the patient, or there's no negligence also. So there are civil aspects and there are criminal aspects also. Sometimes there's a criminal complaint filed because of, now, like in this case also, rash and negligent act done by the doctor. When the doctors acted rashly and negligently and caused death. But very important in such a case to show mens rea, which means intention. So how can there be an intention to kill a patient? This has to be shown, with a lot of burden of proof. Like there has to be enough proof to show that, the doctor not only acted rashly, negligently, but there was intention. But in every case, you don't have to show, some high intention. Sometimes, you can show that, well, it was not a well-meaning doctor. So therefore, you're treading on a very, thin rope, I must say, because both ways there can be some arguments, and all the court needs to see is the standard of proof, which also depends on the medical literature. And but there have been cases, in fact, even recently in last year only, the Supreme Court decided against one of the patients who said that the second surgery had failed. So when the second surgery had failed and the patient had died, she was basically, in the second surgery, when she was not reacting to proper standard treatment, the doctor had put her on Boyle's machine and on automatic ventilator. But the patient died. She died. So Supreme Court said that every case of death need not be seen as a, that happened because of negligence. So on the face of it, you can't be condemning a doctor or considering that this death has been caused because of negligence only. You have to show material record. You have to show from medical literature. You have to show from standard of proof. But the defense of the doctor cannot be, I cannot have any intention to kill this patient. That's no defense. You have to also defend how you are competent, how you follow the standard of care, duty of care of an ordinary competent doctor, not an extraordinary competent doctor. So, point is that when it is such a arguable case from both sides, it takes, now let's come to the, the baggage of litigation. These are long protracted, litigations, and the reputation of the doctor is harmed. So how do you find a solution? Because you are not under authority, and you are in a more dominating authority than the patient. The patient has submitted himself or herself to your treatment and only going by faith. So how do you keep that trust, the human aspect, by talking to the patient? There's talk also, or article by Dr. KK Agarwal. He spoke about how you have to really sympathize, empathize, and talk to patients. Doctors need to spend more time talking to patients, giving them gyan about what they're doing and why they're doing it. Patients will then open up and will start trusting the doctor from that time. then they will not think of such an action. Then they will say, all right, I will live by this doctor's prescription and I will die by this doctor's prescription. This is a standard line used by many patients of Dr. K. K. Agarwal. It doesn't matter. We live or die by his patient, by his. So when it comes to reputation also, this, you have to save the reputation of, like, this talk today is really to show solidarity and come to the rescue of the reputation of doctors, that it should not be spoiled, right? So very quickly, I just want to mention another case which I did against a doctor, in which a very well-known senior neurophysician and neurosurgeon did a spine surgery in Fortis, and the patient, it did not help the patient. In fact, the patient was in such a bad state, had to go for corrective surgery to United States. And there, after the surgery, he was absolutely fine. So what we showed was that, first of all, this doctor delayed on the treatment. He kept giving painkiller injections, kept giving that, and delayed on, the surgery. Then even in the surgery, I think some juniors were used and some bracket that was put on the spine. It was only nutted and bolted from one side, not from both sides. But that happens in some cases. There's a 50-50 chance. In this patient's case, maybe the nut bolts, it was really like a carpenter's job. It did not work well. And all his bones, his vertebrae, are found in pieces in the second corrective surgery in United States, and that's written by the United States doctor, that there were pieces found by the time he came there. So then we showed, when we gave the affidavit of that doctor, the US doctor, what he was saying, how was the patient found. So definitely, your reputation is at harm if you're a very busy doctor and you just use your juniors and you don't take enough care, and a case against you can really harm your reputation and that of the entire fraternity. So therefore, what is the middle path today for us? The middle path is can be not to go for such protracted litigation, and to set up a mediation center. Dr. K. Agarwal already set it up during COVID. And in fact, he had launched it with me even earlier before COVID, but it did not take off. Then in COVID, he announced it, and he started, inviting people for discussions on such aspects. Actually, good mediator, a person who's, like experienced negotiator or a professional who will listen to both sides, and a neutral person can resolve this in a matter of few hours. It's not so complicated. You look at, what the doctor has done, you look at the prescriptions, you talk to the patient, understand the concerns of both sides, and you decide such a case. And it could go, for or against the doctor, but you can find a win-win solution. If the doctor has done some mistake and he admits it, he can compensate it there and then, instead of going for some long drawn litigation, which is hanging as a sword on your head. So my client who had the doctor who had done the cataract operation, which is he had to ultimately compensate that patient. What was the point in fighting up till National Consumer Forum in Delhi for many years? Ultimately, he had to pay that money. He had to pay some money to the lawyer, and he had to pay some money to the patient. He could have done that right away and finished it off in a matter of a couple of days. So this is something that the doctors need to really think of, whether they need to change their approach, A, with consent, proper consent, and B, by talking to the patients more patiently and explaining the treatment to them and hearing them out. And thirdly, if something goes wrong, to opt for mediation first. You can set up a mediation center where you show that we are very fair. We invite patients to come and complain to us, and we will hear you out, and we will see to it that, we will, if there is any room for change, we are ready to do it. So this is all I have to say about, this unfortunate incident, and what is the way forward.
Wonderful discussions, Mrs. Sanghi, and nice. You've given us very brilliant examples as well of other doctors and how medical negligence, sort of comes into the play. I think the key points are that we need to communicate with the patient, and we need to, sort of get us. So what happens, I think, in the Indian scenario is that there are so many patients, and you just don't end up spending as much time with every single patient. And because everything works like clockwork when we are with the patients, and I think that is where we lack, I think, as compared to the Western countries. So communication is key, and getting, you just mentioned about awareness, patient, making the patient aware of their condition, the cataract example that you had given us. So I think communication can go a long way. We can now, the floor is now open for questions. If anyone wishes to discuss something or ask Mrs. Sanghi for her valuable advice, please,
Yes,
this would be the time.
yes,
Yes,
Dr.
please.
Meenakshi, Dr.
Yes, please,
Poddar.
Yes, please, Dr. Poddar, please.
One clarification from Mrs. Sanghi. The mediation which she is talking about, is it, if suppose on mediation we fix a amount, will it be given by the insurance company if I by medical reimbursement company? Medical indemnity company. Suppose I have a medical indemnity.
Yes, I believe there are certain insurance companies who are indemnifying. Doctors are using, hospitals are using, the facility of such insurance companies, and that's up to you. You can do that. Otherwise, you have to pay it from your pocket, of course. Or you can even, if you're part of a hospital, the hospital can take this responsibility, because you need to act freely, right? As professionals, we can't be under pressure to, we won't be able to treat patients. Even a judge needs to act freely. I give judgments freely. Every professional needs to do that.
Because there is some problem in this. If you go for negotiation, then your medical indemnity insurance company will take objection to it. As far as I know.
So it all depends on the contract with them. You can introduce this in the contract, that whether it is a claim that we pay because of litigation in court or out of court. Ultimately, they need to indemnify you for the cost that you have to pay. So it all depends on the contract. It's a contract based. Insurance is always contract based.
No. What I was saying, I have done many seminars on medical legal topics with IMA also, and they always advise don't go for negotiation. I don't have details right now. So they are against it because
I know about that problem. That Dr. K. Agarwal had discussed that with me. I know that in IMA he was not successful because of this reason. But he doesn't believe. He didn't believe in this. He didn't believe
because when he was IMA president, he introduced in IMA also one committee.
But that's why it was not successful, because there was objection to these things. So this doesn't make any sense. You're already very caught up with work, and just sitting over a negotiating table makes a lot of sense. And that's the best way out for so many cases pending. That, I mean, when we thought of this center, the mediation center, we would have been flooded with such cases to be decided. And the NHS of UK, they have set up a whole system for this. And he even sought advice from the person who had set it up for NHS. Dr. Kekerwal had spoken to such a person who had set it up at NHS, and we were going to follow the same pattern. So this doesn't make sense, that we should not negotiate, and there will be no indemnity for that. This doesn't make sense to us.
Anyway, we can have your number. Can we have, you can put, or Dr. Meenakshi can give your number in the chat box.
Sure.
Huh?
Sure, that's
Okay,
fine.
doctor. Yes, yes.
Madam, why the IPC 302 was put on Dr. Sharma?
No, so there can be, all kinds of charges, but the burden of proof lies on the person who's alleging, the patient's family. So you can file any case, likewise, the doctor's family can file case for, damage to her reputation, or even, somebody can take up that cause. So I don't think that, just by filing the case, there's a case made out. One has to see the facts of the case.
No, there is a verdict from the Supreme Court that the IPC 302 should not be put on the doctors.
No,
that's what I said. Only if you can show that this act was done by rash and negligent, and like rash and negligent driving.
But it is very difficult to prove.
Rash and negligence by doctors.
Madam, it is very difficult to prove that the doctor has done this procedure rashly and intentionally.
Yes, it is difficult to prove. So both ways it is difficult. The burden of proof is very high on the person who's alleging. It's difficult to prove, and therefore sometimes even in cases which are genuine, like the patient is rightly complaining, it will be very difficult for the patient to actually go ahead and prove it. So lots will have to be done. Like I said, experts' opinion, going for medical literature and proving it from every angle. So it is not easy. So therefore, there's a lot of gray area on both sides. Therefore, it makes a lot of sense to talk on the negotiating table.
Madam, sorry, I differ. There is no gray area. 302, how can it be applied on a doctor who has operated? It is intentional murder. Even if she is negligent, she didn't have intention of murdering. So 302 cannot be applied.
Correct.
Even
That's what I said. That in criminal cases, mens rea, which is intention, has to be shown. Any criminal case, not just doctor.
How can intention of a doctor can be murder?
Correct. It cannot be.
302 cannot never be applied to a doctor, and that
not 302, but there are other provisions for rash.
304
there are other provisions for rash and negligence also. So I'm not talking about 302, but there are other criminal provisions also. Yes, even in those criminal provisions, mens rea, which is intention, still has to be shown, or very gross kind of negligence and rashness, maybe like drunken driving, that kind of thing has to be shown.
Yes, 304A can be applied, but that also when there is a report from the medical experts.
Correct.
But 302 can never be applied. So that police officer has to be taken care of. We are taking money. IMA is doing that. So 302 fire.
What if there is a case in which the doctor actually has the intention to kill? How can you say that this can never happen? What if there is a case?
A doctor who is operated, how can an intention be to kill?
We are not talking of normal cases. We are talking of a particular case in which there is some story behind which the doctor wants to kill. How can you say that there can never be such a case?
No, because, I'm saying when there is a post-operative death, if a doctor uses a knife to kill the patient, that's not a doctor's duty, na? But if a doctor has operated and the patient dies, that can never be intentional killing. Never be 302. If a patient dies after operation.
All I would say to be technically correct, that there would be a rarest of rare case in which there will be a reason for a doctor to have such an intention, because normally why should the doctor have any intention to kill the patient? So definitely in 99% cases, or I don't know whether to give it a percentage, but most cases there will be no intention. There cannot be any intention to kill.
Anyway, I leave it to for further discussion. But as far as we are concerned, IMA is concerned, 302 can never be applied on a doctor. Only 304, 304A.
So
that's
I
also
think
after a medical board clear.
I think Mrs. Sangi sort of gave us the clue when she said that just for the sake of being technically correct, this has to be mentioned that there can be a very, like, a, even if it's a farcical sort of situation, but there could be a doctor who is misusing the fact that he's a doctor, and something like that. That can happen. There can be someone who sort of hires a doctor or something like that, a farcical situation, with rarest of rare situations. And just so for the sake of being technically correct, Mr. Sangi had made that statement. But yes, I agree with Dr. Poddar that the nobility of the profession is such that we would never be in a situation, and no doctor would ever be in a situation where he would intentionally, even have the thought of killing a patient who is on the operating table.
Absolutely.
So. Yeah, so I think on this note, we may call it a day. I don't think there are any more questions. And if Mrs. Sangi would like to summarize or say the closing note, we can do that and call it a day. We'll be back again next week with maybe more, the medical side of it. I think that we should also, as doctors, have a session on the rights of a patient as well. So to know what is the patient entitled to, what are the medical legal rights. So I think even that would be a nice topic for all of us. So in the future, we would like Mrs. Sangi to please come here and do that discussion as well. But as for today, thank you, Mrs. Sangi, for this brilliant discussion, all those nice anecdotal cases that you have shared, and also letting us into the sort of seeing the medical legal cases from the lenses of Dr. KK. You've discussed with him multiple times, I believe, and getting an insight on his views also was very precious to us. So I thank you for doing this with us today. And if you would like to say anything in the end, I would just hand over the mic to you.
So in
Please
the end,
post Mr. Sangi's telephone number where we can contact her.
I have put it on the chat.
It's there. We can discuss this offline. Yeah.
Sure.
Yes, Mrs. Sangi.
So in the end, I would say it's always the human aspect. We are all humans, is the human aspect in which both the doctors and the patients are, in a situation where the patients are suffering, or their family is really suffering, and the doctor is in a position to really, take them out of that suffering. So I think if they both collaborate and they work collaboratively, and there's a system designed to help them work collaboratively, where there is more awareness, and there is, even it's not just a matter of just signing a consent form on a dotted line. There's, actual awareness given, whether you create more teams to do that, or whether you do these video recordings for consent given by doctors. Then the other human aspect is that when something goes wrong, how, the doctors can take the responsibility and set an example that we don't run away from our duty. We don't run away and then you need to file cases against us. We are right here to still support you. I think that act of compassion, that act of empathy itself will also resolve most of the times it's the pain that the patient is, or the patient's family is already going through. The person has come in pain, and the person is continuing in pain if the relief has not been given by the doctor. And medical science is not an exacting science. So and everybody knows that, including the courts. So therefore, when we know that we are not working on an exacting science, this human aspect needs to be put in practice, because this big oath that doctors take, and if they put this in practice, then there will be less friction against them. And today, when we go to multi-speciality hospitals, why is it that you're always concerned about how you will be fleeced, how there will be wrong surgery prescribed wrongly? You need to consult or take second, third opinion. I myself have done it. So this trust needs to be restored, and that trust will be restored only by act of empathy, by talking, communicating better, and if there's something goes wrong, talking over the table, across the table. which is through mediation. And ways can be found out. It doesn't make sense to say that there is no way, and there will, the approach for a medical, the IMA is sadly, not helping the doctors. So what IMA does when a complaint comes is that they give 30 days time. The doctor has to reply to the complaint, and then, what's the point in that also, right? Taking 30 days, and you can finish this off in 2 days. So if IMA wants to set a better example, they can actually open their mind to, doing mediations, helping doctors with mediations, giving them more awareness. Like doctors have opened their mind to Ayurveda because of this pandemic. I think we have all evolved and opened up to other possibilities. This is one big possibility which the doctors need to open up to, and they will really feel that it has taken a big burden off the doctors' fraternity.
Thank you, Mr. Sanghi, once again for doing this with us. It was an absolute pleasure to hear you and all your stories and the anecdotes that you have shared with us. So I think the take-home message for the day is just communicate more. It's good for your patient. It's good for your practice. The patient, you will retain patients better. And, it'll also take care of the medical legal aspects. If you just explain why, certain medications are given, a lot of complications probably can be, sort of averted, and there would be better, sort of compliance as well. So I think the take home message, again, as I said, would be communicating with the patient more, and that would be a solution to a great many number of problems. So on that note, I'd like to call it a day. Thank you everyone for joining in and keeping this show alive. We'll be back next week, and we'll be intimating you about the topics shortly.